For any witnesses here, I apologize that the floor session took a little longer than we expected, so I apologize that we can't do anything about that. Would you record your vote, record your attendance, please? We do have a quorum. All right, let's take care of a little bit of housekeeping first. Senate Bill 1535 should have been assigned to transportation, so I would ask for a motion to do that. Properly moved and seconded that bill be transferred to transportation. Record your votes. Okay. I'm sorry.
Thank you, President.
Okay, all right. Since Senator Vogel is here now, her bill on music therapy should be re-referred to Ed and Health. Is there a motion? Second. Record your votes, huh?
I didn't know that was happening.
It is now. Okay. These three bills will not be heard today: 1238, 1356, and 1589, because they're all being worked on or not ready for prime time. I had, 1589. I had planned to do the casino one first, but Senator Marsden supposedly was going to leave town forever. No, had some folks here who were going to fly. We needed to catch a plane. So is he here? He's not here, so he's lost his opportunity. Okay, Amiga, would you describe the substitute bill on the casinos?
Thank you, Mr. Chairman. Wow, my well-paid pages are passing out the substitute. Here's what the substitute does, and I'll give you page and line references. It is a substitute for Senate Bill 1126, Senator Lucas's bill, and it will incorporate Senate Bill 1503, Senator Carrico's bill, Senate Bill 1706, Senator Lewis's bill, and it basically does 6 things in putting that substitute together. And those 6 things are, Mr. Chairman, on page 29, line 759 to 766, it adds a locality. Any city with a population greater than 200,000. It has a provision that requires that the gaming operation be conducted by a Virginia Indian tribe. It's granted federal recognition, and the language is there. The second thing that it does is on page 29, line 767. It's a provision that provides that the board can only issue one gaming license or gaming operator's license per each category that's listed in subsection B. The third thing that it does is on page 46, line 1199. There is an additional regional distribution that covers the additional region that is described. And that's, I think I said that's on page 46, line 1199. The next changes are all on page 50, which is the last page of the draft of the substitute. There are 4 enactment clauses. The first of the new enactment clauses requires the lottery board to review casino gambling laws in other states and report any findings and recommendations to the chairman of the Senate General Laws and Technology Committee and the House General Laws and Technology Committee by November 1st of 2019. The next new enactment clause would prohibit the lottery board from issuing a gaming license to an operator prior to July 1st, 2020. And the last additional enactment clause is for emergency regulations to be promulgated by the lottery board.
Okay. Senator Carrico, did you want to speak to the
Well, just
substitute?
briefly, Mr. Chairman, I just want to do an overview of everything that we've worked on. As you know, the original amendment modified the localities descriptions and added Danville to it. The technical amendments from the lottery and state police were added to the original amendments. And now, based on the agreements that we reached over this weekend, up to 5 localities will be approved to have a single casino, and that would be Bristol, Danville, Portsmouth, Norfolk, and Richmond. And as far as the study is concerned, it will run concurrently as the authorized localities under the legislation move forward with their referendum, keeping everything moving in the process. The purpose would be for it to gather the best practices as a part of the regulations promulgated through the process, and it would be time certain for the study to be completed 11/1/19 date proposed by the governor, so that the promulgations process can continue and move forward as the referendum is voted on. A license could be issued by the lottery. A license could not be issued by the Lottery Board until 7/1/2020. Going this route does several significant things. The one thing that I have pushed for the most is it puts the decision, the ultimate decision, in the hands of the people of the jurisdiction directly impacted, including those associated to the Pamunkeys, and it eliminates the need to negotiate a compact. And it puts all casinos, including those granted to the Pamunkeys, under the control of the Commonwealth, and they'll be regulated by the Lottery Board. And it eliminates the issues and need for exclusivity for the Pamunkeys, and the Commonwealth will directly benefit from the same tax structure with them as that applies in other casinos, and basically creates a level playing field and single structure for all. So there was a lot of movement over the weekend, a lot of considerations that this committee had asked for, and the substitute does those things that were looked at by this committee.
Thank you. We had extensive opportunity for people to weigh in on Friday afternoon, so we will not hear any testimony. Is there anyone on the committee that has a question of either the amigo or the proponents? Senator Abbott.
Really briefly, you said Richmond. Did we talk about Richmond as a site last week with all the others?
I don't know what you discussed last week.
Well,
as far as I was gone. I was probably in Charlottesville by the time you had that discussion, but I know that was part of the description of the population piece.
Okay.
Senator Evan, that was not in discussion on Friday.
Okay, maybe I can ask the chairman or someone else. How did Richmond? I'm just curious about the Richmond piece. Is that negotiated for a certain reason?
That was the negotiating point that.
Yeah, I think I can
Some
get
felt
you an
necessary.
answer to that.
Richmond was in the bill, is what I'm being told. Richmond was in the bill.
Mr. Chairman, members of the committee, Senator Evan Edward Mullen on behalf of the Pamunkey Indian Tribe. Chief Gray could not be here today, but he was pleased to be with you on Friday. Richmond, the description of Richmond was in the population limits in the bill that was discussed on Friday.
Okay, and one final question. Does that mean that Richmond, the Pamunkey tribe, could be included without it being competing with Norfolk without competing with Portsmouth as directly, if they chose to have a casino here?
Mr. Chairman, Senator Evan, the bill that's before you includes both Norfolk and Richmond and Portsmouth. It includes all of those.
Thank you.
Yes, sir. Thank you.
Any other questions?
I didn't know.
All right. Is there a motion? Yes. All right. All right. We need to, the substitute needs to list 3 co-patrons, three patrons, Senator Lucas, Senator Carrico, and Senator Lewis, and roll them into 1126.
So moved.
Excuse me one second, okay. All right, so there was a motion to second to roll them in as a substitute. Please record your votes.
Just to roll them in?
Yeah, this is just to roll them in, okay. Now, if there is a motion, it would be to report and re-refer to finance if it's a favorable one. Properly moved and seconded that the bill be reported and re-referred to finance. Any further discussion?
Mr. Chairman?
Where be you? Who spoke? Oh, David, I'm sorry, Senator Sutherland.
Yeah, I thought I heard someone just say it's just a study. I'm not a fast enough reader to read all of this in the few minutes we've had of it, but it doesn't look like it's a study to me. It looks like it's just the first step in a few-year process to making it happen. And like I said, I'm not a quick enough reader to read all this, but what it says is, so I just go to the end and read the enactment clauses because that's usually the most important part. And I don't see anything in there that suggests that the study will determine anything other than maybe what future General Assemblies might want to do. It says, reenactment clause 3, that the Virginia Lottery Board conduct a review of casino gaming laws in other states and report any findings and recommendations to the chairman of the Senate Committee on General Laws and Technology and the House Committee on General Laws on or before November 1, 2019. And that's it. It's not, there's nothing else. It's just a study to say, hey, here's what other states have done. Now, you've already started the process. You might want to make some adjustments. It seems pretty fast moving to me. I don't think this is just a study that folks earlier today suggested to me I might be seeing later today. This is a whole lot different than sending something to JLARC for JLARC to review. This is a gambling bill that has a small provision for a study in it. So that's why I'll be against advancing the bill at this time.
I'm going to ask, unless one of y'all wants to answer, I'm going to ask Martin or Jason.
Jason.
Mr. Chairman, members of the committee, Jason Ige from Bristol Resort and Casino. This enactment clause allows a study to go concurrent with the regulatory process, but it would legalize the opportunity to establish casinos in those 5 jurisdictions. So that the bill is not just a study. It does allow for the casino. It also allows for the referendums for those localities to proceed with that while the state studies what the regulatory scheme and framework should look like. And the license would not be issued until July 1, 2020. So that would allow the General Assembly to make any other changes or modifications in the next session. But it does allow these communities to go to the next step of planning for a casino, to allowing for the referendums to occur, but not the promulgation of the regulations.
Senator Sutherland, did that answer your question?
Thank you, Mr. Chairman. I think that the comments, I imagine you have had the opportunity to read the whole bill, which I haven't yet, but I imagine that if I did read the whole bill, I'd find that your assessment was accurate, that the study is a small part so that we could see what regulatory scheme Virginia might want to pursue after it's already legalized gambling, casino-style gambling, which is what this bill appears to do, and I hope to read it later.
Senator Sutherland, it will have to go to finance if it's approved here. I assure you that finance staff will comb through it very well, as probably House Appropriations will go through it very well. So this is not the final step. Any further questions? All
Mr.
right.
Chairman, just really quick, Surville.
Okay, well,
Thank you. I raised a lot of questions at the hearing on Friday, and I still have questions. The tax rate concerns me because it's lower than every state but Nevada or New Jersey. I have questions with the RFP process for working with these casinos. Is going to be a lot of things, but I view this as a process, And this bill is probably going to get amended by 3 or 4 more committees and the governor by the time we finally get it. And in general, I support legalizing gambling in this state. MGM has been sucking hundreds of millions of dollars out of this state up in Maryland, right across the river from my house, for 4 or 5 years now. And I've been saying for 4 years since I've gotten in the Senate and supporting my colleague from Portsmouth that we need to do something about it. And in that spirit, I'm willing to advance it so that the Finance Committee can figure out what kind of tax rate and regulatory, who ought to regulate it, and then the governor can chew on it. But there's definitely a lot more work that needs to be done on this. I don't question that at all. So that's why I'm voting for it.
All right, no further questions. Record your votes. Okay. Bill is reported.
Sorry, wait, I meant to put, yeah, hit the button. Okay, there it is.
Ayes 9, noes 3. 1 abstention.
All right, thank y'all for coming. Thank y'all for working over it. All right, come on up, Nick. Welcome.
Thank you, Mr. Chairman. Senate Bill 1568, and I do have a line amendment.
Okay.
Yes,
You want
Mr.
to
Chairman.
report the line amendment, please?
SB 1568, it's line 22, after more than, strike,
Brooks, there's a little noise out there. Pull the mic closer to you.
sorry about that. Is that better? Is that better?
Yep.
There we go. So SB 1568, line 22, after more than, strike 1,200 and insert 1,000.
Mr. Chairman, speaking to the line amendment. The line amendment is more in keeping with what the national standard is becoming in this country. And so I would recommend that we debate the bill today based on that number.
Okay. We want to describe the bill?
Yes, sir. This bill reduces the number of school hours required to get a cosmetology or barber's license from 1,500 hours to 1,000 hours. The hair industry has had a very difficult time finding new people to come into the industry because of the barrier of the licensing requirement. As you know, DPOR is under guidance from the General Assembly to reduce regulations by at least 25%. This is right in line and right in keeping with that. This is opening the door for people's careers because it will reduce the amount of time necessary to get such a license. And hopefully, because of the reduced amount of hours, it will also be a reduction in cost, although that's a free market decision that the General Assembly does not control. That's a free market decision based on cosmetology companies, and people can make their own decisions there. We don't control that. This bill is supported by a great number of folks, including the Ratner Companies, who owns 1,000 hair cuttery storefronts. They are privately owned and headquartered here in Tyson's Corners and have 174 stores and 1,900 employees in the Commonwealth. You know, we submitted a FOIA request, the folks who brought me this bill, a request to DPOR, and found out that very few founded complaints directly against barbers or cosmetologists. This is not an industry that needs to be overregulated. We are confident that the reduction in hours will have no impact on customer care and protection. And as you know, this is the real reason why we as governments regulate industries, is to provide safety to our citizens. We also looked at trying to reduce the fees and charge to students by the hair schools, which can be $20,000 to $25,000. But the Ratner Companies felt this approach was much better for all involved. And again, I do hope that the price comes down because the number of hours go down. And so I hope we can get behind this bill to get people trained for careers that can be rewarding and beneficial to them. It helps our business environment. It helps people. And I'd ask that you support the bill and take any questions.
Okay. Is there anyone here to speak in opposition to the bill?
Good afternoon. My name is Cassie Stroth with McGuire Woods Consulting on behalf of Beauty Basics, Rudy and Kelly Academy, Paul Mitchell, and the Ogle School. And while we appreciate what the senator is trying to do for the industry, this bill really changes the industry standard. 46 states require at least 1,500 hours for cosmetology, including our neighboring states of DC, Maryland, West Virginia, Tennessee, Kentucky, and North Carolina. And as you know, as the senator mentioned, JLARC recently did a study of DPOR, including this board, and this was not a recommendation of JLARC to reduce the number of training hours. And finally, we think this change could affect reciprocity agreements, current and future, with other states. And for these reasons, we hope you'll oppose the bill. Yes, sir.
You mentioned some surrounding localities.
Yes, sir.
What do the majority of the states require?
46 states require 1,500 hours for cosmetologists, and about that many require for barbers as well.
That is the standard.
That
with
is
some
what,
deviation.
yes,
Okay.
and at least 1,500 hours. Some states require 1,800 hours, some a little less, 1,200 hours. Very few require just 1,000 hours.
Thank you.
Thank you.
Anyone else wish to speak in opposition? All right. You want to see, are in favor of it? All right, come on up.
Mr. Chairman, Rob Bohannon, representing the Virginia Retail Merchants Association, and wanted to thank Senator Marsden for bringing forward this bill. Several of our members very interested in this bill, Hair Cuttery being one, JCPenney's another. Like a lot of businesses, we're interested in providing a quality product at an affordable price. And you'll hear from some folks within the industry that'll talk about how this bill will help them and how the current environment is detrimental to that. So I'll let you hear from them, but we support the bill.
Senator Locke.
Yes, ma'am.
Rob, how do you respond to the issue of reciprocity?
I'm not familiar with all the different states on this. I believe we have reciprocity with North Carolina.
We do. We have straight up, I'm sorry, Matt Bentke with the Ratner Companies. We do have straight up reciprocity with North Carolina. Every state is different with reciprocity. Some of them allow you to perform a certain number of hours of work in exchange for hours of lessons learned, but it's different with each state. Now, I'll say clearly that the national trend is moving downwards to the number of hours, and we have several people that will testify to the fact that and the reason that folks are going to lower hours is because it's more than enough to fulfill the requirements of the 3 accepted practices for training cosmetologists and barbers. So I hope that answers, but I've got some other people that are more learned in this as well.
Well, did you want to follow up on that? Then I will follow up on it. Yes, you said you have reciprocity with North Carolina now. What is their requirement today?
My understanding is that with North Carolina, it's straight up. I mean, even if we changed our hours, you would still be able to.
What is their requirement today if I lived in North Carolina?
Oh, I don't. Sorry, sir. 1,200.
And you do not believe that they will change that reciprocity if we go lower than them?
I do not believe so. The national trend for cosmetology and barbers is lowering in hours.
I appreciate that.
Yeah,
but
I
I'm
have-
talking about reality.
Yes, sir.
Okay.
I have no indication that they would.
Okay, thank you.
Yes, sir.
Okay, you wish to speak? Welcome.
Thank you, Mr. Chairman, members of the committee. Keith Kostick, and I'm the area developer for Sport Clips, the local area developer for Sport Clips. Sport Clips Haircuts is a national chain, 1,800 plus stores across the country. I don't know, 15,000 employees, give or take, it changes. Locally here, we have 62 stores open. In Virginia, 45 stores with about 400 cosmetologists. You know, I think that every industry is focused on differentiating ourselves. However, with this one, the concept of hiring good stylists is across the board. It's for everybody. It's the individual salon, it's chain salons, and it's franchises, right? And the number of hours are definitely a barrier to entry for a lot of folks, and you know, it increases the time the student can start bettering their lives, increases the time the student can start moving towards their objectives, whether it's buying a new car, buying a new house, whatever it is. So for those reasons, and for we as a brand and us certainly support and thank you for considering moving from 1,500 hours to 1,000 hours.
Okay, thank you.
Thank you.
Welcome.
Hi, Mr. Chairman, members of the committee. Thank you for the opportunity to speak today. My name is Kim Schottler, and I love this industry. I've been with Great Clips for over 22 years. Great Clips is the largest salon brand with over 4,400 salons that employ over 40,000 licensed professionals. In Virginia, there are close to 100 Great Clips salons that employ over 1,000 professionals. Hair is hair is hair. Why does it take 1,000 hours to go to cosmetology school in New York, Massachusetts, Vermont, and 1,500 hours in Virginia? 500 hours more. There's no proven evidence that cosmetologist graduates from Virginia are better prepared for the workforce. In regards to some facts, I'd like to just share a few facts, including facts from an independent third-party industry study called the AIR Report. It's the examination of the cosmetology licensing issues. 8 states have lowered hours for cosmetology programs in the past 2 years. It is the state's responsibility to ensure minimum safety. 1,000-hour states receive the exact same safety and infection control training as the students do in Virginia. 1,000-hour states pass the licensure exam rates at the same as the Virginia school students do. There is no relationship between the total curriculum hours and wages. Graduates of programs 1,500 hours and more earn no more on average than graduates of a 1,000-hour program. More hours force students to stay in training longer, resulting in higher student loan debt. Shorter programs create a more diverse workforce since barriers to entry are lower. The higher the number of hours required for licensure, the fewer licensed cosmetologists per capita in the state. Longer courses do pose a barrier to entry into this profession. There are 2 education providers in our industry, Pivot Point and My Lady. They use the same textbook, whether you're in a 1,000-hour state or a 1,500-hour state. This should be not about schools or salons. It should be about what does a student need? What does a student need? It's proven in New York, Massachusetts, Vermont, that a student can successfully graduate from cosmetology school at 1,000 hours. Why keep them in school 500 additional hours? I respectfully urge you to act on this bill.
All right. Is there any new information coming forward, or are we going to?
One last.
Okay, all right, as long as we're making some progress here.
Sure.
Welcome.
Mr. Chairman, members of the committee, my name is Gary Ratner, and similar to what was stated a little bit before, we operate Hair Cuttery. We operate about 1,000 stores. In the state of Virginia, we own and operate 190 stores, 2,200 employees. I've been a licensed cosmetologist since 1983. Over 35 years in the state of Virginia, and an instructor. We open stores and create jobs and employ cosmetologists to serve the public. We could open more stores with more available labor to create more jobs. We're here to ask the committee for the opportunity to lower the hours to 1,000 hours to make it more attainable to be a cosmetologist in the state of Virginia. We operate in states in other states that have 1,000 hours and up. And the quality of students and care of the clients in 1,000-hour states is the same as it is in higher hour states. I have a partner that has a school in the state of New York, which is 1,000 hours, and they graduate very proficient and very safe cosmetologists. 1,000 hours would be just as safe in Virginia as it is in other 1,000-hour states. We need more people in this industry, and you can help us by voting for this bill. We thank you very much for your consideration.
Thank you.
Mr. Chairman,
Senator Reeves.
unless anyone else wishes to speak or the committee has questions, I think we're in good shape on this bill. I'd make a motion to report the bill.
All right, I want to ask, if y'all want to raise your hand if you are in support of this bill? All right, is there anything new that we haven't heard? Okay, thank y'all for coming. All right, so the motion, well, let's, I don't know that we move the amendment. So first of all, let's, again, would you report that amendment?
Line 22, after more than, strike 1,200, insert 1,000.
Okay. You've heard the amendment. All in favor, say aye.
Aye.
All opposed? Okay. Senator Reeves, your motion is to pass the bill as amended?
Yes, sir.
Is there a second? Second. Properly moved and seconded. Any further discussion? Hearing none. Record your votes.
Ayes 13, no 0.
That bill is reported.
Thank you, Mr. Chairman.
All right, the next one up is Senator Howell, and as she comes forward, Senate Bill 1369 was referred to this committee. It should have gone to courts. I would ask for a motion on that.
So moved.
Probably moved and seconded that Senate Bill 1369 be re-referred to courts. Please record your votes. Or not.
More work for you.
All right, Eric, get on stick here. All right. Okay, that bill is referred to courts. Senator Howell.
Thank you, Mr. Chairman. I have Senate Bill 1651, and it's setting up the Partnership for Innovation and Entrepreneurship. I'm sure we all agree that entrepreneurship is critical to job creation, and access to capital is key for entrepreneurial starts and successes. According to the Economic Innovation Group, 50% of new firms have been created in just 5 metropolitan areas nationwide, and sadly, Virginia is not one of them. We're falling behind peer states and the country in entrepreneurial success. Virginia lags behind peer states such as Colorado, Utah, Tennessee, and Maryland. And we lag behind in seed and early stage capital for entrepreneurs. Our entrepreneurial ecosystem is thriving, but it's totally disconnected. Virginia is for Entrepreneurs is a collaborative that has connected the 9 ecosystems across Virginia in a backbone organization. In nearly every ecosystem, there are accelerators, seed funds, university programs, co-working spaces, and more. Virginia is for Entrepreneurs launched an investment marketplace for entrepreneurs seeking capital and investors looking to provide risk capital to entrepreneurs. As an example of the demand and disconnection, over 1,000 entrepreneurs and over 100 investors signed up for the marketplace. This bill, the Partnership for Innovation and Entrepreneurship, helps connect the innovation and entrepreneurship ecosystem, streamlining, simplifying, and improving the path that investors and entrepreneurs have to success. It does 2 main things. First, it simplifies the bench to license process within universities by removing barriers that prevent inventors from commercializing technologies. This improves upon what has been done out of VRIC, the Virginia Research Investment Collaborative, by better connecting university research to the business community. It also connects inventors and entrepreneurs to the Commonwealth's innovation ecosystem by creating a backbone division that helps quarterback the relationships between entrepreneurs and the programs, resources, and capital that support them. This improves on past efforts which have invested at the firm level, providing capital to specific firms. This effort invests in the ecosystem level, providing a level playing field for all entrepreneurs. Mr. Chairman, I believe there are other bills dealing with this. Madam Chair.
Yes, ma'am.
I believe there are other bills dealing with this, and finance, this has to go to finance, I'm sure, is working on various ways to sort of get them aligned
Together.
with each other.
Okay.
Yeah.
Is there any member of the committee has a question for the patron? Senator Eben?
Yes. I like what I'm reading here about some of the purposes, but I was just wondering, besides merging other organizations, is the broadband or any of the other purposes for this organization new, or are we just being more efficient?
I think it's an effort to streamline and be more efficient.
Okay, thank you.
I think there are other bills dealing with the broadband.
Okay, anybody else? Senator Reeves?
Senator Howell, there's a lot of striking out, but my gist is all the striking out is going under the main title of the new organization. Is
Yes,
that the gist
yes.
of it?
Yes.
Okay, thank you.
Anybody else? Are there any members of the audience who wish to speak in favor? Anybody opposed? Okay, this has to go to finance, Mr. Chair.
Properly moved and seconded that the bill be reported and re-referred to finance. Any further discussion? Hearing none, record your votes. Okay, thank you.
Thank you.
Okay. Senator Chafin. Senator McClellan. Welcome.
First, I have a substitute, and let me explain what the substitute does.
Tell us which bill first.
I'm sorry, this is Senate Bill 1438. As introduced, it was an omnibus bill to amend the Landlord-Tenant Act to address a number of issues that have been identified as a result of the evictions crisis. When this bill was drafted, the Housing Commission, which was addressing the same issue, had not yet voted on what proposals it was going to reach consensus on. So the draft sort of included a overarching list of items that had been identified by the Poverty Law Center through stakeholder groups that they had to address the evictions crisis. Once the Housing Commission decided what it was going to do, what the substitute does is, because individual Housing Commission members did individual bills out of the consensus reached by the Housing Commission, I have pulled those provisions out of this bill so that now this bill does three things, which I'll outline in a minute. But the three things that the bill does either were not addressed by the Housing Commission, or the Housing Commission did not reach consensus. And so what the bill does is, first, would give tenants a right to attorney's fees from landlords when they successfully defend eviction cases. Second, would prohibit landlords from evicting tenants simply because they haven't paid their late fees. And then third, gives tenants more time to pay their rent by changing the pay or quit period from 5 to 14 days. I think the committee is well aware of the eviction study that came out that showed that Virginia had 5 of the top 10 eviction rates for large cities. One of those was in my district, the city of Richmond. I have a constituent here who would like to testify. She actually contacted my office, I believe it was over the summer, because she was facing eviction, and we were able to help her in that situation. But Delange Feld would like to testify about her experience today.
Welcome. How are you doing today? Good.
Virginia makes the eviction process very fast and appealing to landlords. Once a written notice is received, it only takes 5 days to pay before filing the eviction. The notice must give the tenant 21 days to fix the violation, or the lease will terminate at the end of the 30-day period. In my experience, my particular property is like a lot of other private housing companies, control companies, that have all but automated the eviction process, which makes it easy to immediately evict someone or put someone in a process of eviction. And that's what happened to me this summer. And I came out of work in April, and I'd lived where I was living for a year and a half. Never been late on rent before. I'm the mother of one little girl, and my stability is very important, as we know, for anyone with a family and with a child or children. And it put me in a place where I had to hurry up and try to find finances, which is a process. When you've lost your job, or when you're in between jobs. So even though I never faced this before, I found out a lot about the process itself, especially here in Virginia. And because I was able to reach out to Senator McClellan's office, they were able to help me with the process. But I learned a lot. And I just want to say that a few days, a few more weeks would make the process for someone who is in between the situation, or just needs a few, because at that particular moment, I only needed like $300. So that's all I needed. But with late fees, attorney fees, and those type of things, it made it almost double what I had to pay before. So of course I had to get those finances and that amount together as well. And with my little girl, I didn't want to have to face not having a place to live, and that affects her education. That affects everything. So I just want to say that the time, which is 14 days rather than 5, would at least give you a little bit more time to get the resources together and not have to face court costs and those type of things. And I had to talk to my property manager, but because of the way the laws are made, and the housing company and management company that I was living under, they went strictly by the process. It didn't take into account that I had never been late before. It didn't take those things into account. It just went through the process.
Okay, thank you for coming today.
Thank you.
Senator McClellan.
Amigo reminded me there is one line amendment to the substitute, just to.
Well, let's adopt the substitute first. We could substitute for 1438. Properly moved and seconded. All in favor say aye. Aye. All right. Now, what's the amendment to that?
I think it's technical to be sure we've removed the pieces that are covered in other legislation.
Yes, Mr. Chairman. The amendment will basically be removing the reference or removing from the substitute section 55-248.4 and 55-248.7. So the only thing that will be remaining in the substitute will begin on page 8, line 203.
All right. You've heard the motion, the amendment. Is there a motion? You're looking at the substitute? Is there a second? Properly moved and seconded that amendment be added to it. All in favor say aye. All opposed? Okay. Everybody's getting tired. Is there anyone here to speak in opposition to Senate Bill 1438? Welcome.
I'm Chip Dix on behalf of the Realtors, and just like to say we appreciate Senator McClellan working with us and discussing this bill with us. As was mentioned, there was a 6-month study in the Virginia Housing Commission, and there were 6 pieces of legislation that came out of that Housing Commission work group. The Poverty Law Center participated in that. Senator Locke chaired the Neighborhood Transitions work group where all those evictions bills will work through. The issues that are presented to you today have not been discussed in the Housing Commission. They are objectionable to the landlord community and the housing provider community for various different reasons. And the first one is today, if you think about when the rent is due, the rent's due and payable on the 1st of January late on the 5th. Then you send your 5-day material noncompliance notice for non-payment of rent. The pay or quit doesn't exist under the VRLTA. It goes to like the 12th or 13th of the month, and then the 12th or 13th of the month, the landlord may file an unlawful detainer at that point and get in court roughly in 30 days. So you're in court on February 15th for January's rent. What this would do is to, in our opinion, change tenant behavior by, if you're basically run your 5-day notice period and you expend it somewhere in the neighborhood of 12th, 13th, 14th of the month, and you add another set of days to that, 7 days to that, you're talking about the 20-something of the month. And if a property owner owns a single-family house, which the VRA applies to single-family houses, then under that circumstance, how does the property owner pay their mortgage payment when they haven't received the rent? So there's a big picture issue here fundamentally that we think is flawed with the 14-day pay or quit, as they've been calling it, versus the 5-day pay or quit. The second provision is with respect to attorney's fees. And when you think about that, so if one of you is the landlord and I'm the tenant, I contract with you to pay my rent on time. And if I don't pay it on time, what happens is that you send me a 5-day notice, I have an opportunity to cure, and then you take me to court. And finally, when we get to court, after you've gone through all those hoops, if I don't pay and don't show up in court, or either one, then under that circumstance, you're entitled to attorney's fees. So what this provision does is to say that any time that you go to court against me, if the case is dismissed for any reason, then all of a sudden you owe me attorney's fees. And I would suggest to you that that's not reciprocal and that's not a balance appropriate. And again, the tenant has not gone through anything in terms of giving a notice and an opportunity to cure and those type of things like the landlord's required to do. The last piece of this bill deals with the so-called late charge issue. And what happens is that if I don't pay the rent on time in January, as I've talked about within the 5 days, the late charge attaches to that. And then likewise, if I haven't paid the rent by the court date on February 15th, again, there's another late charge that's talked about. So one of the things we worked on in the Housing Commission was the eviction diversion program, which allows tenants that have a one-time situation, loss of wages, medical event, whatever, in those pilot programs to be able to catch up and not continue to have late charges. So we think that is a good step in the right direction in that regard. At the same time, if the landlord doesn't pay his or her mortgage payment, they incur a late charge. And so there's lots of things to think about with respect to the late charge provision. So the idea that solely because the tenant owes some of that money would suggest to you is not a well-thought idea. So my suggestion and recommendation would be and request would be that you not proceed with this bill. If you decide to send it to the Housing Commission, it can be looked at further. None of these issues have been discussed in the Housing Commission. We appreciate your consideration.
Thank you.
Thank you, sir.
Welcome.
Thank you very much, Mr. Chairman, members of the committee. My name is Brian Gordon. I'm here today on behalf of the Virginia Apartment and Management Association and the Apartment and Office Building Association of Metropolitan Washington. We also ask for your opposition to the bill. As Senator McClellan and Mr. Dix did note, the Housing Commission has endorsed a package of legislation. Several of those bills are on your docket for later this afternoon. And without repeating too much of what Mr. Dix already mentioned, I would note that specifically with regard to the recommendation to extend the 5-day pay or quit notice to a 14-day period. The Commission did endorse a concept that we do believe addresses the same issue to a degree, and that is the extension of the right of redemption timeline to allow tenants to additional time to scrape together the funds in order to avoid an eviction. And we think that at least partially addresses the issue that provision is looking to, it addresses the same goal. So with that, I would ask for your opposition to the bill.
And that portion is in Senator Locke's legislation.
It is in.
Okay.
Yes, sir.
Thank you. Welcome.
My name is Elena Ferranti. My family owns about 200 apartments in Colonial Heights, Virginia. My father immigrated from Sicily. He is the very essence of an American dream, and he chose apartments as his business. I'm here today to ask you to oppose this bill because it makes it really hard for us to help our residents. Extending the notice period means that a resident can be up to 3 months behind before they even end up in court in some jurisdictions. And catching up when you're that late is very, very hard. Our process in Virginia is no faster than most of the other states, but in a way, it can actually be better because it keeps the debt smaller and easier to pay back for our residents. As far as attorney's fees go, Mr. Dix had it exactly right. Sometimes we show up in court and the resident brings money and we dismiss the case of our own volition. We don't want any residents to have to leave because they can't afford to pay our rent. But in that case, we've chosen to dismiss. We would still owe attorney's fees, which just seems completely wrong to me. So that's more of an incentive to evict someone rather than an incentive to keep them in our homes. And then late fees, let's just all admit and say what it is. Without late fees, why would anybody pay their bills on time? It's the incentive that mortgage companies and credit card companies and even cable companies use to get people to pay rent on time, and it is something that we have to be able to collect. Otherwise, we won't be able to pay our bills. Keeping small owners or medium-sized owners in the marketplace is a good thing. You just passed a bill to promote entrepreneurship, and overregulating the apartment industry will actually have the opposite effect. So,
Thank you.
Thank you.
Welcome.
Thank you, Mr. Chairman. Randy Grumbine. I represent the Virginia Manufactured and Modular Housing Association. I second the comments previously made in opposition. We did do good work in the Housing Commission, and we will support the legislation that comes up later today. Thank you.
Thank you. Is anyone here to speak in support of the bill?
Mr. Chairman, members of the committee, Christy Mara with the Virginia Poverty Law Center. I want to thank Senator McClellan for the work she's done on this legislation. And I do want to speak to each of the points that Mr. Dix made about the 3 changes in this bill. But I first want to say, as he pointed out and as others have pointed out, the Poverty Law Center and other tenant advocates were very involved in the Housing Commission process. We very much support those 6 bills. However, we think even more can be done, and we think that it is appropriate and incumbent upon this committee to consider the substance of this bill and the changes that it makes, because we strongly believe that these changes can further help to reduce the evictions in the state of Virginia. And when you have as many evictions happening every day as we do here in Virginia, I think any step to reduce them as quickly and as soon as possible without any burden on being placed on the landlord would be appropriate. And I think all 3 of these things do just that. First, in terms of the pay or quit or termination notice based on non-payment of rent being extended from a 5-day notice to a 14-day notice, contrary to the example that Mr. Dix gave, we believe that this change will actually keep people out of court. Very few people will receive a paycheck, and very few people's relatives will receive paychecks in a 5-day period. But in a 14-day period, most people will have a way to get those funds. And so we believe that changing the notice period to a 14-day period will allow many more tenants to pay not only the rent they owe, but the late fees to make the landlord whole and keep people out of court. Secondly, in terms of the attorney's fees, I think Mr. Dix may have mentioned that most written leases do require tenants to pay the landlord's attorney's fees if the landlord has to take the tenant to court to enforce the terms of the lease. This simply says that if the landlord takes the tenant to court and without the consent of the landlord, which is what the substitute says, the case is dismissed, then the landlord is obligated to reimburse the tenant for his attorney's fees. So if it were the case that the landlord wanted to work with the tenant and the landlord consented to the dismissal, the tenant would not be entitled to attorney's fees under this substitute. The only time he would be entitled to attorney's fees is if there was a dispute that was litigated before the deciding body, before the judge. And we believe that this legislation, this provision of it, would actually discourage landlords from filing suit when they didn't have clear evidence of a violation of the lease and would actually promote settlement. And
Thank you,
then,
Christie. But we can't keep going forever.
thank you, Mr. Chairman.
But you made your points, I think.
Thank you, Mr. Chairman.
All right. Senator McClellan, you want to wrap up anything?
I think, Christy started to outline the reasons why we believe that these provisions will help reduce evictions, and I don't think I have anything else to add to that.
Okay, thank you. Any questions? Is there a motion? Yes, Senator Evan. You had
Yeah, before there's a motion, I just wanted to ask, in terms of the chronology, so under this bill versus under current law, right now you have 5 days to say your rent is late and we're going to start to begin proceedings. Is that right?
Yes,
And this would give us 10 days?
14.
14 days. And then either way, you end up in court 30 days later, would be the typical or first date possible?
I don't know what the first date possible would be, but I think typically the
Okay.
idea behind this is if you have time for another pay period, you're more likely than not going to pay the rent and avoid going to court anyway.
any further questions? Is there a motion?
Mr. Chairman,
Senator Pike.
there's a number of bills in relation to this
Yes.
that the Housing Commission has worked on, and I think there are still some questions that are, I think worthy of some further explanation if we get the follow-up with the Housing Commission to understand also how this would work or some of the potential issues with also the changes that are also on our docket today.
I think that Senator Locke, when she was chairman of the Housing Commission, she did an excellent job, and I think that getting everybody to hear it outside the pace of this General Assembly is good. So I think, are you about to make a motion to refer it to the Housing Commission?
Yes, Mr. Chairman.
Okay.
Move to PBI gently with the letter to the Housing Commission for follow-up on the elements here.
Okay, is there a second? Second. Probably moved and second, the bill be PBI'd with a letter from the committee to the Housing, instructing the Housing Commission to look at the issue. Any further discussion? Hearing none. Record your votes. Okay, thank you.
I'd just add that since I probably won't be here when you hear the other portions, that Mrs. Feld also supports the work that the Housing Commission did, as do I, and strongly encourage you to vote for those.
Thank you. I think there's strong support for that. Okay, Senator Chafin.
Thank you, Mr. Chairman. I'm here on Senate Bill 1274, and there is a substitute.
Properly moved and seconded that substitute for 1274 be adopted. All in favor say aye. Aye. All right.
So, Mr. Chairman, the substitute it provides some technical amendments. It addresses the use of the RFP process and it gives a 10% point advantage to the pharmacy schools and ensures the results tested in these labs can be properly certified as analysis in courts. So the committee members likely know that the Department of Forensics, because of this overburdening drug problem that we've had in the Commonwealth and the United States, has a well-known backlog of controlled substance analysis cases. That backlog was 13,589 cases as of January 1, 2019. Forensic Science, Division of Forensic Science has projected that these cases will only continue to increase over the next 5 years. And so recently, DFS put out a RFP, but unfortunately, no laboratories located in Virginia applied for that RFP. So in Southwest Virginia, this idea came to us and was brought to us by the pharmacy school that's in Southwest Virginia, because it's very often that we have law enforcement officers that drive all the way to Richmond, for example, to bring these samples in to be analyzed. So the Appalachian College of Pharmacy came forward and was interested in investing their own resources to help to solve this problem. And I reached out, Senator Locke and I partnered on this initiative because she represents a pharmacy school in her neck of the woods in Hampton, and then there's another pharmacy school that would be interested in this out in the valley in Winchester.
Senator Chafin, is there any opposition to the bill?
Not to my knowledge.
Let's find out real quick before you talk us to death.
Okay.
Is anyone against Senate Bill 1274? I think you've explained it excellently. Probably moved and seconded that the, well, let's back up 1 second. This is going to have to go to finance, so the motion, proper motion would be.
There is no finance. There is no.
I am looking at a sheet that says 1274, Chafin wants to look at it.
They're not investing any money in it. Okay, I understand.
Probably moved and re-referred to finance. All in favor, record your votes. All right, thank you, sir.
You are a good chairman, Mr.
Right.
Senator Ruff.
Senator Peterson.
All right. End the suspense. Senate Bill 1401. This is a request from the Department of Forensic Sciences. It's a very simple bill. It's about, I think, one sentence long. It simply has to do with when a employee of the Department of Forensic Science is moving contraband materials, whether it's a weapon, whether it's drugs, child pornography, but when they have possession of it pursuant to their employment, their scope of agency, that they are not committing a crime. And this prevents us from having to put this in the code every time we have some type of contraband that's put in the hands of DFS. So this is done at their request.
Okay. Is anyone here in opposition to Senate Bill 1401? Hearing none, is there a motion? Properly moved and seconded. All in favor, record your votes. Okay. You're good. Don't worry. Senator Edwards.
Mr. Chairman, members of the committee, this is the bill you've been waiting for 3 years. It took that long for the Code Commission and Amigo Wade and 29 members of a working group to put it together. We can do one or two things. We can read it. It's 321 pages long and 16,808 lines.
Senator Edwards, would you mind if we hold this to the last bill and we'll let you talk to whoever stays?
Well, I think we can do it very quickly.
Okay, all right.
All seriousness aside, it's a recommendation of the Code Commission. The last time property and conveyances, Title 55, was revised has been never since the 1950 Code of Virginia. It took 3 years to put this together, 29-member work group representing the relevant regulatory bodies, banking community, court clerks, real estate, common interest communities, landlords and tenants, and local government. It's got 5 major parts. It was a unanimous report of the Code Commission that it be reported. And again,
any questions?
If you have any
of the
questions, Amigo can answer them all.
Is there anyone here in opposition to the rewriting? Is there a motion? Properly moved and seconded that Senate Bill 1494 be reported. All in favor say aye. Wait a minute, I'm sorry.
It's Bill 1080.
1080,
Bill
I'm sorry. I picked up
1080.
the wrong number.
It's the biggest bill I've ever had.
All right.
I hope ever to have.
All right, that one is reported. All right.
Okay, thank you, Mr. Chairman. Members of the committee, you'll be proud of yourselves. Senate Bill 1494, it relates to firefighters and emergency medical technicians. It has to do with the Procedural Guarantee Act, which is already in the code. The problem is there's no remedy for violating the Procedural Guarantee Act. So what this does, it provides that any breach of the procedures required by this chapter for the benefit of firefighters shall create a cause of action against the employing agency in favor of the firefighter or emergency medical services personnel that was subjected to interrogation. It basically it allows the right to go to court to enforce it. Right now, there's no enforcement mechanism. Virginia Diamond and somebody else is here to speak in favor of the bill.
Okay. Welcome.
Thank you, Mr. Chairman. I'm Virginia Diamond speaking on behalf of the Virginia Professional Firefighters. The Firefighters Bill of Rights provides some basic protections for firefighters and EMTs who are faced with potential disciplinary interrogations. They get notice, written notice. They're allowed to have a witness, et cetera. So they're allowed to receive a recording if there is a recording. From what our firefighters have told us, there are certain jurisdictions that simply ignore this, and they don't have any remedy. So what they're seeking here is an opportunity to be able to go to court without having to establish any prejudice, but to get some incentive in the code for their jurisdictions to comply with these basic protections.
Mr. Chairman,
Senator Reeves.
does this include volunteers?
No, this is for employees.
Is there anyone here speaking in opposition to Senate Bill 1494?
Also, Aaron Rice was here. Might want to speak in favor. I've just been given for the first time a amendment in nature of a substitute. Are you familiar with this?
This is the House bill.
Oh.
But we were going to just continue on with the.
Okay, without this.
The bill as you have it.
Okay, all right, without this. All right.
All right, let me make sure I understand. You're not offering this substitute?
I just saw it.
Mr. Chairman.
This is the bill that's going to come up in the House, and so.
Mr. Chairman, my question is for Amigo. I'm not a lawyer, although I play one in courts of justice, but I don't read where it excludes volunteer firemen. So I would assume that volunteer firemen that are qualified at the same level as an active fireman that's an employee under the same training standards would be considered under this bill?
It's 32.1-111.1 is the definition. I'm not sure what it is.
Mr. Chairman, Aaron Rice with the Virginia Professional Firefighters. It's my understanding that in most localities, volunteers are just that, volunteers, so they're not treated as employees, so they wouldn't be under this bill.
Mr. Chairman, as a follow-up, don't mean harm, but I do think it's a valid question because even though it's a volunteer relationship, there is an employment relationship in relation to that to be covered under line of duty death provisions. There are other provisions that are covered within the statute. And so I'm not sure if we could get counsel to further clarify without causing harm to the bill, that would be helpful.
Mr. Chairman, if we could add also, while we're clarifying this, add the EMS, because I know if a volunteer firefighter or voluntary EMS is injured while in the performance of their duty,
right here, yeah.
comes under the city, county, or
Yes.
town's
Okay.
risk
We have an
management
answer.
fund, and they're treated just as an employee
Yep.
at that point in time.
The definition of firefighter in the Firefighter Bill of Rights is any person who is employed solely within the fire department or public safety department of an employing agency as a full-time firefighter whose primary responsibility is the prevention and extinction of fires.
Mr. Chairman, the bill here, and both of the bills in the original and the substitute, on both of them, it says employing agency in favor of the firefighter or emergency medical services personnel. Now, in a lot of jurisdictions, the EMS personnel are solely voluntary. In Virginia Beach, we have a handful of paid. Everybody else is volunteer, and we have thousands of volunteers in that. So they're treated as employees And I just want to make sure we get clarification before we move forward on this. I don't mean any harm to the bill, but I think it's important to clarify that before we move it forward.
Senator Edwards, I think it's best that we take a look at this for a week and come back on it.
Mr. Chairman,
Senator Pike.
I think Ms. Diamond's definition under 9.1-300 does satisfy the requirements that it is full-time, meaning it's an engaged salary and not volunteer at this point for this code section. So I'm comfortable that it does narrowly define and not open it up to much wider.
It's not volunteer because they're volunteers. They're not covered by the existing code.
Mr. Chairman?
There was a question about, you also had a question about EMS, did you not?
And Mr. Chairman, it's if you read the bill, and I'm not saying anyone didn't, I mean that as you read the bill, it says any breach of these procedures required by this chapter shall create a cause of action against the employing agency in favor of the firefighter or emergency medical services personnel that was subject to interrogation. Well, in Virginia Beach, and I can only speak for Virginia Beach, we have thousands of EMS volunteers, and they're treated as employees where we only have a handful of paid EMS employees. So the way I read this, it covered both volunteers and paid firefighters and EMS personnel. Now, if that's not how it is, then I may have a different position on the bill, but the way I read it, it covered both. And if there's an investigation, if they're injured, they all are treated as if they were paid employees.
I think we best put this off for a week and deal with it. See if y'all come to some terms.
Just if it is put off for a week, I just want to suggest perhaps by inserting the word paid somewhere that might assist.
That might be the solution, if you get with the patron on that. Okay, thank y'all. Appreciate it. Senator Edwards, did you have another one? Okay, thank you. All right. Senator Stanley, are you here? Okay.
Good evening.
Welcome.
It's good to be here. Mr. Chairman, presented for your consideration is Senate Bill 1676. Mr. Chairman, I have the pleasure and honor of serving on the Housing Commission, which is chaired by one of the most fantastic senators in the whole planet ever, Senator Locke. Hopefully that will make sure I got at least one vote on this bill.
All right, keep moving. It's getting late.
This bill is part of the landlord-tenant reforms that we are putting forth in a package of bills that the Housing Commission considered this year. It basically does some simple things. Number one, it requires a landlord to offer a written lease. A written lease in the legal sense protects both parties, but most importantly, it protects the tenant in the way that we're trying to have this occur. Each party would have the same rights and obligations as if there was a written lease. So if there is not a written lease, the terms and conditions are presumed by operational law. And it found within the bill those presumptions are as follows. That rent shall be paid in 12 equal installments. They're due on the 1st of the month and they're late on the 5th of the month. The rent will be an amount agreed upon by the landlord and the tenant. And if there is no agreed rent number, then it shall be found at fair market rent for value of the place that is being leased. If the rent's paid by the tenant after the 5th day of any given month, the landlord is entitled to charge a late fee. The landlord in this presumption can also collect a security deposit not to exceed an amount equal to 2 months of rent. And the parties may enter into a written agreement at any time during that 12-month tenancy at sufferance. And quite frankly, what the law says here is that where there's no written agreement, then that shall be a 12-month lease, non-renewable unless the parties agree to otherwise, or it becomes a month-to-month thereafter.
Okay, thank you. Is anyone here in opposition to the great work the Housing Commission did? Hearing none. Is there a motion? Properly moved and seconded that bill be reported.
I just want to ask one quick question.
Sure you can.
When it says that you have to divide the rent in 12 equal periodic installments, or fair market value? Does that happen anywhere, that you just don't have a figure agreed on? Yep. Okay.
Thank you for that answer. I appreciate that.
All right. Record your votes. That bill is reported.
Thank you, Mr. Chairman, members of the committee.
Senator
Appreciate it.
Locke, since we've gotten into the discussion of housing, thank you. Go ahead and do yours.
Every vote.
Thank you, Mr. Chairman. Senator Stanley started on our eviction bills, and I have the others.
Are they as controversial as his?
Not at all.
Have these been worked out by the Housing Commission?
All of these have been worked out by the Housing
If
Commission.
everybody in support of this compromise would raise their hand, we can end a lot of discussion. Sounds pretty universal. Is there a motion? Probably moved and seconded. Don't worry about that detail.
Which one? Which one?
Senate Bill.
Senate Bill 1445 has an amendment.
Let's hear what the amendment is
Yeah.
first.
Senate Bill 1445, line 51 of the introduced bill after order, insert, if the tenant pays all amounts due as provided in this section, any judgment for possession of the dwelling unit shall be voided, and the officer shall return the writ of possession to the clerk who executed it.
Has that been circulated around? Chip, wake up.
I move the amendment.
I'm going to ask if that was circulated since the agreement came earlier. Is this your amendment, Senator Locke, or is this its suggestion of somebody else?
No, is that our amendment?
Madam Chair, could I inquire where the amendment came from?
Whose amendment is this?
I didn't think you were putting it on there. I think that was one that I did, that I then gave to Senator McClellan. It's not one that I thought you were putting on your bill.
I don't think there's an amendment
I don't think that this is not our amendment.
No, I don't think we've discussed the amendment as a stakeholder group.
That's probably best.
Oh, I'm sorry. Yeah, this is the Attorney General's amendment.
Oh, I haven't seen it.
I don't think we've seen that one either. Okay. Could we take a look at the amendment?
Senator Locke, you had two of them. Can we do the other one while they're debating that?
Okay, let's go to Senate Bill 1448.
Is that part of the group? Same
This is a
group?
part of the.
Okay, all right.
And this one simply eliminates confusion between an order of possession and a writ of possession by renaming the writ of possession a writ of eviction.
All right. Anyone speaking opposition to this bill?
Move the report.
Properly moved and second that Senate Bill 1448 be reported. Any further discussion? Hearing none, record your votes. Okay. All right, that one we've dealt with, okay?
Somebody needs to vote for Adam.
We got to adopt a sub.
I can't vote from here.
You can from up there. You could have. I don't know if he's, it's not working. Well, it's closed. You want to reopen, please? All right, record your votes again.
You had a substitute with it? We adopted.
No. This is 1448. Come on, Eric, keep up. Okay, that one is reported. Senator Locke, did you have another one?
You have a substitute for 1448.
This is on 1445. There is no amendment. Is there a motion to report? Properly moved and seconded that Senate Bill 1445 be reported. Any further discussion? Hearing none. Record your votes. Okay, that one is reported. All right, what about 1444?
Secretary of Technology, Secretaries of Administration.
Okay, have you finished the housing ones? No, all right, it went to the next page. Okay. 1449 or 50?
1449 is a rental home, which was not, 1449 is established a residential executory real estate contract, which is a basically rental home.
1425, we removed the repetitive, so it was a straight report, 14.
Okay, is there anyone in opposition to Senate Bill 1449? Hearing none, is there a motion?
Second.
Properly moved and second that Senate Bill 1449 be reported. Record your votes. All right, that one is reported. Okay.
Okay, the last one I may have to have Chip come up and talk to, and this one has to do with the eviction diversion pilot program. It was a part of our package, and it would create a pilot eviction diversion program in 4 localities: Richmond, Petersburg, Danville, and Hampton, to begin July 1st, 2020, and last for 3 years with a sunset.
Mr. Chairman, members of the committee, Chip Dixon, again, this is part of the overall package. We worked on this for 6 months. Apparently, the Office of the Executive Secretary of the Supreme Court has a substitute that proposes to expand this statewide. And again, that was not the consensus of the Housing Commission, and we'd ask that you reject that substitute proposal. This pilot program is designed to identify what changes need to be made in the law and whether the eviction diversion program works, as we think it will. The idea of the expense of putting this burden, as we heard from the Supreme Court during the Neighborhood Transitions Work Group, the burden on the deputy clerks in the General District Court to do that statewide, we need to see if this eviction diversion program works first before we expand it statewide. So that was the reason that the commission felt like that the best thing to do was to have it in the pilot program. I will say that the Office of the Executive Secretary was not enthusiastic about the bill. They expressed that in the work group, and they've given a fiscal impact statement. One of those positions will be a data clerk to basically compile this data so we can all look at the data. And the plan would be in the summer of 2022, the Housing Commission would look at the data. We had suggested during the discussions that OES might have a facilitation group, and they indicated that that was not within the Supreme Court's mission to do that. So we took that out and gave that back to the Housing Commission. And the intent here is between 2022 and the 2023 session that the Housing Commission would make a recommendation back to the General Assembly on whether to continue the eviction diversion program, whether it should be modified, what it should do in terms of trying to really move the needle on keeping people from being evicted. So that's the purpose of the eviction diversion program.
Okay. Is there anyone here in
And
opposition?
there is a budget amendment in for this.
Is there anyone here in opposition to the bill? Senator Black.
If I could just make a comment first. The idea is tremendous. I think it makes great sense, and it seems to be pretty straightforward. I know one of the concerns that I have heard about this is kind of a separation of powers issue where the courts are sort of required to respond to requests by the Housing Commission. I apologize for not putting on my mic. But in any event, I think that will be addressed. And it's not that there's any opposition I know of to doing this program. The program seems to be a very good one, but I think perhaps a little bit of rejiggering could be at least considered.
Let's hear from the witness.
Mr. Chairman, members of the committee, my name is Brandy Singleton. I'm with the Office of the Executive Secretary. I want to clarify that we have no objection to the meat of the policy of this bill that is before you. And if you look at the bill before you at lines 52 through 100, we take no position on that whatsoever. It is rather the way in which this pilot program has been structured. And I also want to, and our concerns with that are threefold. First of all, there is the open data request element of this that would have the Housing Commission asking these courts for data without specifying what that data is. If it is data that the court currently collects for the purpose of tracking these cases, it is not problematic. But because it is structured as an open-ended, what data the Housing Commission may request, that is what makes that piece of it problematic. That is also what raises the separation of powers issue, as does the enactment clause that speaks of the Housing Commission evaluating how the courts are running these specific dockets. Therein is where our concerns lie. Senator Black very kindly heard our concerns and asked Legislative Services to draft something that would address those. This is not OES's substitute, but rather a very generous attempt to address our structural concerns with the bill. And we don't have a position on whether this is statewide or time or space limited. It is rather the superstructure that has been placed around this that was problematic for us.
Thank you. Is anyone else to speak in opposition? This one has been requested by the finance staff, so the proper motion, if you should choose to do so, would be to pass and re-refer to finance.
Mr. Chairman, would it offend the patron if we took this by for the week until the next session, just to have some final discussion before moving forward?
Mr. Chairman, it would not, but what I am concerned about is that OES was present during the entire discussions that the Housing Commission had over the interim in discussing all of this. And at no time was it discussed relative to them doing any of this. And at one point, we did have OES in as the body to collect this data, and they did not want to do it. So that's why they were taken out. And the Housing Commission put in as the body to collect the data. And also, this was not discussed with me as the patron of this bill. So that concerns me.
Well,
so I am not, I have no problem with taking it back for the week.
Senator Locke, you will be here next week. So
I will be here next week.
maybe a little, if you can rub out some of these problems that do or do not exist in the week. Okay. So we'll carry that one over to next week.
Okay.
I
have one more that's quick if you don't.
Okay.
And that one is 1444, which basically the Secretary of Technology position does no longer exist, and 1444 basically transfers the operational responsibilities of the former Office of the Secretary of Technology to the Secretary of Administration and responsibilities related to commercialization and entrepreneurial support to the Secretary of Commerce and Trade.
Okay. Anyone in opposition to this cleanup? Hearing none, is there a motion?
Second.
Properly moved and second that Senate Bill 1444 be reported. No other conversation, then record your votes.
Don't forget me, Frank.
All right, that one is reported. Okay. Since we carried one of mine over from last week, I'm going to try to do this one that I can't remember about anymore.
over, Jill.
Getting ready.
Slide on over.
Senator Ruff, since you're so prepared, you want to just spout one off?
1529.
Can everybody refer to
1329. All right,
Senate
thank
Bill
you.
1329?
Last week, we heard the issue of double indemnification. We had several folks who talked about it and spoke about it. We got hung up on one issue. The compromise that we have proposed is that it remain at double the amount of the contract, and that however, if the Secretary of Administration feels that there is an issue that needs to be dealt with in a different realm, it can be done.
Madam Chair, I would make a motion to move the amendment.
Okay, the amendment's been moved and properly seconded. All in favor of adopting the amendment, please say aye.
Aye.
Opposed?
Amendment
Okay,
in
the
form
amendment's
of a
before us.
substitute.
And then form of a substitute. We got it.
Okay, form of a substitute.
All right.
All in favor? Please
Aye.
signify by saying aye.
Aye.
Okay, it's properly before us.
Okay. I think you heard plenty about it last week. It deals with the fact that we are not getting some contractors interested in doing contracting with the state because they are afraid that they will lose too much if their entire business is put on the line if something goes wrong. This would limit it to twice the amount of the contract, their liability, and then if in the contract process, the Secretary of Administration could be called upon to allow it to go higher than that.
Okay, are there any members of the committee who have a question for the patron? We heard from both sides last week. Is there anybody who wishes to make one final comment before we vote? In favor?
Madam Chair, I have one brief question.
Senator Suderline.
Just to make sure I understand the process. So it would be the Secretary of Administration would be the one that makes the sign off on the recommendation of the CIO?
I'll let my crack
Is that
team
correct?
here if it goes up.
Madam Chair, Chris Nolan on behalf of CGI Technologies, but also a member of the coalition that's working on this. Yes, the way it would work is that the original bill of 2x of contract value remains. And then if the CIO believes that this presents basically an exceptional risk to the Commonwealth, he or she may make a recommendation after doing a risk assessment to the Secretary of Administration. And in that recommendation, some multiple of contract value for an overall cap. And then the Secretary approves that, and that becomes part of the RFP and the terms and conditions so that everyone understands the Commonwealth's rationale for increasing the cap beyond 2x. And then finally, there's transparency provision that requires annually all of those recommendations be posted in one place so that the General Assembly and others can keep track of what those recommendations were. So,
One quick follow-up then.
Yes, Senator Suderline.
Thank you. So the CIO essentially will review every one of these in practice and determine if the double indemnification is the correct policy for the Commonwealth should pursue in that case. So basically, if something doesn't work out, the CIO is who we're going to call in and ask about this.
and I'm certain the CIO will call the Secretary to join he or she.
I think so. All right. Sounds very good. Thank you.
Is there anybody else who has a question or comment? Bill operates on a motion.
Move to report.
Okay, the motion's been made and properly seconded to report Senate Bill 1329 with a substitute. And the motion also needs to be to re-refer it to the Committee of Finance. Okay, all in favor, please vote aye.
Ayes 13, noes 1.
Okay, the bill reports. Amigo, who's next? Serval, Senator Serval.
These are two Housing Commission bills. First one, I guess, 1537.
Okay.
Okay, 1537 is a bill that this committee's been hearing for 4 years now. And we finally figured it out. This has to do with home-based childcare. And I don't know if you all remember the bunch of people lining up and complaining on both sides and how we need more childcare. Basically, what this bill now says is that in any locality that classifies home-based childcare as an accessory or ancillary use under their zoning ordinance, that an HOA is allowed to prohibit it, but their ban and their covenants or their rules has to be specific and say no home-based childcare. They can't say home-based business and then violate people and say that includes childcare. So we had, I don't know, 2 or 3 meetings about this Housing Commission. My friends with the Community Association Institute are now okay. I think we have peace in the valley, and so I'm hoping we can pass it.
Is there any member of the committee who has a question for the patron? Is there anybody in the audience who wishes to speak in favor of the bill? Don't everybody stampede.
I didn't ask him to
stampede
come.
at once.
I didn't ask him to come this
Okay. Anybody who wishes to speak in opposition to the bill?
Move to report.
Okay, the motion's been made and properly seconded to report Senate Bill 1537. All in favor, please vote aye.
Caught me off guard there. All right. That one is reported, and you want to go for the next one?
Yes, sir. 1538. So 1538 is a bill that I introduced last year, and then I voluntarily referred it to the Housing Commission at the request of the CAI, and who had some common interest in trying to fix this issue. What this bill does is basically 2 things. Number one, it requires HOAs, co-ops, and condo associations to actually publish their budgets to their members. Right now, there's actually no requirement in the code that you get a budget every year. And this makes it clear that you have to give them a budget. Number one. Number two, it makes it clear that the budget document must also tell all the owners exactly what their reserves are and how deficient they are in their reserves, so that it's right there in front of them. They can see they're not saving enough money to pay for these capital components. HOAs not reserving enough money is a real problem, and by getting this information to homeowners, it's my hope they'll create the pressure to raise the assessments to fund their sidewalks and parking lots and pools and dams and things. And I believe there's peace in the valley on this also.
Is anyone here in opposition to Senate Bill 1538?
And Ms. Palin wants me to also say we have the endorsement of the Housing Commission, which approved this bill also.
Is anyone here in opposition? Hearing none.
Second.
Properly moved and seconded that Senate Bill 1580 be reported. Record your votes.
That's all I have,
14,
Mr.
no
Chairman.
0.
That's all I have.
Okay, thank you. Senator DeStef.
Mr. Chairman, members of the committee, today I'm here with Senate Bill 1374, which is a by-request bill. What this bill does is basically provides that any person who willfully violates any provision of the Condominium Act is guilty of a misdemeanor, the penalty for which, for each violation, is subject to a fine of not less than $1,000 or double the amount of gain from the transaction, whichever is greater, but not more than $50,000. A jail sentence of not more than 6 months, or the penalties in both clauses, I and II. Under current law, the penalty is applicable to certain provisions of the Act, including for failure to comply with filing and registration requirements, public offering statements, and escrow of deposits. Now, Mr. Chairman, let me give you an example of what happened here, which is why I'm carrying this as a by-request bill. One of my constituents is a member of a condo association that had a $3,000 in their reserves. They had a $650,000 assessment for a new roof, and they've not published a budget. They've not discussed a budget. So they went in and assessed everyone $10,000. Now, in that condo association, we have a tremendous amount of older folks who are on fixed incomes, a lot of military widows, and my constituent was extremely upset that everybody who was on a fixed income was assessed a $10,000 assessment, and the fact that they hadn't provided a budget for 2 years. So he thought that everybody should be penalized and held accountable on the board for each violation. And that's the bill, Mr. Chairman.
Mr. Chairman.
Senator Reeves.
So the bill that we just passed from
Serville?
Serville, Senator Serville, I'm sorry, I'm getting tired too. That would have remedied this actual instance.
Mr. Chairman, Senator Reeves, yes, it would.
Okay. So,
Without putting people in jail and hitting them for up to $50,000 on every instance.
Got it. Okay.
However, every once in a while, we do need a heavy hand.
Is there anyone here who wishes to speak in opposition to this bill?
Good afternoon, Mr. Chairman, members of the committee. Pia Trigiani here on behalf of the Community Associations Institute. And I do agree with the heavy hand, but not in this instance, Senator. The legislation has always provided the remedy of criminal and monetary fines for a developer of condominiums. This would extend to volunteer board members and even individual owners who themselves violate the statute, which I think may be not what is intended, but that's where it would go. It would have a chilling effect on anyone serving on these boards. The statutes with respect to reserves, the story that the senator told is an unfortunate one. The bill, as Senator Reeves pointed out, that was just reported out of committee, would help in some respects. But it's up to the individual boards of these community associations how they reserve. We recommend they reserve. They don't always follow that advice, but this is a little bit too heavy-handed in our view and would really be debilitating for community associations.
Mr. Chairman.
Thank you.
I have a question, Ms. Trigiani. Do you have any concerns that if this was enacted, that condo associations might have a problem getting D&O insurance?
Yes, because board members are indemnified and held harmless under the documents, and that indemnification is supported by directors and officers liability insurance, which I think is your question. And so you're right, it would probably impact the ability to get insurance for any action. And they, as you know, we can be sued at any time for any reason by anyone, and that's why we carry insurance. Thank you, Senator.
Mr. Chairman, if I can wrap it up, this actually was not meant for developers. This is specifically aimed at and meant for those individuals who are serving on the board and not doing the job. So when they're on the board, that board's not doing their job, they should be penalized heavily.
Thank you. Senator Abbott.
So you're suggesting that they go to jail for up to 6 months, each of the board members?
For each and every act that violates this provision of the law. And again, this is by request. I'm carrying this for one of my constituents.
Mr. Chairman.
Okay.
Is your constituent here, Senator D. Steph?
Let's see. Mr. Gregory was here earlier. He may actually have given up and gone home. Yeah, he was here earlier.
Okay.
I think he got here around 10 o'clock today.
Mr. Chairman, I'd like to move. I think the committee has possibly addressed a couple of these issues with other bills we've just passed, and I'd like to move that we gently PBI this bill.
Second.
Is there a motion? All right, I'm sorry. All right.
Mr. Chairman, I renew my eloquent, gentle motion to PBI the bill. I think the committee has dealt with some of these
All right.
issues.
Record your votes. PBI, yes. Blame that on Eric.
Mr. Chairman, members of the committee, thank you so very much.
All right. All right. Senator McPike.
Mr. Chairman, if we could go to 1442, we'll do some quick cleanup. This, as you know, I've been working on a number of mobile home items for the last couple of years. What I'm proposing to do is to ask the committee to PBI with letter for this to Housing Commission. I've had some agreement to do some additional work, but with the underlying premise that what we're trying to solve is ultimately where we have folks in housing and also land transfers, that we need to provide a mechanism where there are ownership of these lots that are not really mobile anymore. You can't really transfer them, but giving folks an opportunity to collaborate and purchase the underlying land use. And so I'd like the Housing Commission to study these type of conditions where we have land use transfer and transfer of property as a context, and I think that'll get to a part of what is going on in this bill. So, Mr. Chairman, I'd move we PBI with a letter.
That the bill be PBI'd with a recommendation for a letter to go to the Housing Commission. All right. That one is dealt with. All right.
Mr. Chairman, Senate Bill 1671, I believe we're going to take by for the week, which is on charitable gaming.
That would be correct.
And that leaves Senate Bill 1463, and we have some line amendments to pass out from technical draft adjustments, and I'll
Properly moved and seconded that we adopt the line amendments. All in favor say aye.
Thank you, Mr. Chairman. What this bill sets out to do is to clarify in our grant process for where we have incentives for jobs across the Commonwealth. What this seeks out to do is to clarify to make sure that also telework jobs are also included underneath that umbrella. And so this is important to many of our districts, but also mine, where we have long commutes, and we want to encourage teleworking. So we need this helps to clarify the code and clean it up so we can make sure that there's a broad array of folks that don't necessarily need to use, whether it's 81 or 66 or 95, in order to apply for and receive the grants under some of the economic incentives. And this is a request also in partnership with Virginia Economic Development Partnership.
Well, before, as you're coming forward, Senate Bill 1580, we will deal with next week. There was a question about taking the bill. Senator Dance wanted to roll her bill.
You're right. Mr. Chairman, we've already passed this out, so she just asked legislative services to make her bill identical for free up next week.
Okay. All right. Over the course of the last, somewhere I have the bill number. Senate Bill 1523, over the course of the last few years, we have tried to focus our attention more on workforce training. We created a governor's persons to be able to sit at the table. We think that the next step forward really should be to create a secretary that would probably command a little more respect. No offense to Megan, but and we need to get some of the agencies under that. Currently, we have the Secretary of Commerce and Trade trying to oversee a number of departments, agencies, and that means he's spread out pretty broadly. So the concept is to make the secretary, make the workforce position a secretariat, and probably put the VEC, Adobe, some of those bills that deal directly with employment issues under that position. Excuse me. Megan, you want to define it any better than I have? While she's coming forward, there is a substitute.
Mr. Chairman, I would move the substitute.
All right. Proper moved and second, we adopt the substitute for Senate Bill 1523. All in favor say aye.
Aye.
Okay. All right. Megan.
Good evening. I'm Megan Healy, Chief Workforce Development Advisor. So I'm probably the most excited person in this room about this particular bill. Over this past year, my position has been elevated to cabinet level. So I directly talked to the governor, report about all workforce issues. Department of Labor, a lot of our federal funds do flow through me, and I'm accountable to a lot of our reporting to the federal government on particular Workforce Investment Opportunity Act. And so this position is just kind of, even though I'm elevated at cabinet level through executive order, this just kind of makes it into code about me, that I possibly have a little bit more authority and oversight over particular programs and agencies.
Mr. Chairman,
Senator Reeves.
does Go Virginia come under this?
Not currently in this bill. This bill doesn't mention the substitute, but that is under Secretary of Commerce and Trade.
One more question, Mr. Chairman. Who's paying for this? Is it coming in the governor's budget?
So currently, my salary is paid through Title I funds, which are through the Virginia Community College system, and 15% of those funds are discretionary funds of the governor.
Okay.
So my staff's paid through those, so that's particular.
So if we pass the bill, does it need to go to finance?
Yes, it does.
Okay, Mr. Chairman, barring any testimony, I would make the motion.
I have one question. What agencies will come under this secretariat?
It's under Section D, I think.
It
Under
would be,
Section D. Section D?
it would be the Employment Commission and the Department of Labor and Industry.
Line 166 on?
And so that was the substitution. Before, it just had the governor can move agencies, add or subtract agencies by executive order, which every secretary says that.
I think that's 168 through 184.
Did that complete your questions? Okay.
Mr. Chairman, then I would renew my motion barring any other comments that we report and refer to finance to substitute.
Before we do that, let's check and see if there's any opposition to the proposal. Hearing none. Your motion? All right. Any further discussion? Hearing none, record your votes. Okay, that one is dealt with. All right. Does anybody else got any more bills? Donovan's, yeah, I think so. Pike. Okay, hearing none. Okay, anything else? Okay, meeting is adjourned.